So I'm officially going to open the Hemposium, which is organised and largely credited to that woman with the dreadlocks there, Miss Guidance. She's done an awesome job. And now I'm going to do a little welcome to country. Hello, Alex. And, it's nice being a white fella doing a welcome to country because, I've got a big soft spot for black fellas. They were here at least, say, 100,000 years. We haven't been here 200. What a fucking mess. So for me, my welcome to country is a big apology. And I watched that Q&A recently and what's his name, Dark Emu? Bruce Pascoe was on there and he was sort of irritated a bit, and right at the end he said, we've got this culture, oldest living culture on earth, working in harmony, living in harmony with the earth forever. Why don't you guys have a look at what we did? Maybe you could learn something, And that's exactly how I feel. So nice to just take a moment to reflect on where we're standing, whose country we're in. And I really appreciate you all coming. It's quite a trip. I think I made a mistake yesterday to Murdoch Press. They rang me up and they said, "How is it?" And I said, "It's like swimming through crocodiles to get here." They got excited by that. Anyway, I already met Deb Lynch this morning, who's got one leg just busted by the roadside drug testing. She'll lose her licence automatically for 3 months. It's just disgusting. So I really appreciate this man, ex-Magistrate David Heilpern, who has spoken up so loudly about it, and still I feel like we're hardly getting anywhere, but we've got to be inching forward. Hey, Davo. Anyway, he's possibly made the ultimate statement, living the truth by quitting his job because he couldn't comfortably at all keep taking people's licences away, amongst other things perhaps. So, it made me realise that on the other side of the fence, being a criminal for 50-odd years, which is just infuriating, for using God's gift, which they called it for thousands of years in India. So we've known each other a long time with Steve. I think the two of you wrote a book on cannabis law reform 25 years ago. How well do they know the subject? So really grateful you're both here. Steve has been here forever, comes every year, answers hundreds of hassling emails from us at the Hemp Embassy, which David can now get from us too. Awesome. And I'll leave you with them. Thanks very much. Thank you very much for coming, because we won't get a huge crowd. It'll just make it more intimate, I reckon. And it's not just the cops, who they've pretty much killed MardiGrass for stoners with their roadblocks for the last 5 years or so. But it's also no backpackers, no overseas visitors this year. And then there's the corona fears. So you guys have swum through the crocodiles and I really appreciate you coming. Thanks.
Thank you.
Thank you, Michael.
Thanks very much.
And a big thank you to Michael, because there at the Hemp Embassy, they are actively engaged in what I consider to be the biggest act of civil disobedience in Australian history. Now, that's a big call, but what they're doing every day, those people, is risking their lives and their liberty for their beliefs to provide medicine to Australian people. So let's hear it for the Hemp Embassy.
Dave and I have had no discussion about what we're doing today, so this will be a very free-form event. Thank you again for all coming. It's been mostly a Q&A session. The topic really generally is how the laws work and so on. We're both lawyers of different sorts. And so it's mostly a Q&A about some of the detail. Obviously, we probably all agree, well, we all do, that the law is stupid and should be changed, etc. Happy to talk about that a bit. But the main focus of the session really is not how stupid it all is, but how does it work and what does it mean for yourselves and for your friends and family in terms of practical day-to-day lives. Very, very short introduction. There's legislation that makes it illegal. The broad legal system is laws passed by Parliament, mostly, some that were inherited over many, many years. This law is done by Parliament, the Drug Abuse and Trafficking Act. It makes it an offence, criminal offence, to do anything in relation to cannabis and other prohibited drugs. possessing it, supplying it, growing it, helping someone else to supply it or cultivate it. All of those particular acts are legal offences, criminal offences. The seriousness of the offence, broadly speaking, depends on how much is involved, a small quantity in your pocket or 600 plants growing in your back paddock, and your record and other things sort of come into play in terms of sentencing, but it's the type of behaviour and the quantity involved that creates the actual offence that you've got to deal with in court. Police have to prove things beyond reasonable doubt. Broad advice from lawyers, generally speaking, for the whole of human history. Defence lawyers say, don't talk to the cops, for all sorts of good reasons, and that's always a good starting point. I don't know if David wants to say anything by way of introduction. His first MardiGrass for many, many years.
First MardiGrass for 22 years.
Unrestrained.
I couldn't come for 21 of those years because I think I would have got, dragged before the Judicial Commission and then Parliament and then sacked. So here I am. I was at the very first one, speaking in this hall, talking about... I told a story then and I wanted to tell it again just by way of startup, which was I used to represent... Steve and I have both really been drug lawyers all of our working lives. We wrote a book together called Rough Deal, Your Guide to the Drug Laws, about 30 years ago. It was a guide for users to avoid going to jail, really. And one of the tricks that I used to do when I was in practice in the Nimbin area was, of course, the guys were all on good behaviour bonds for cannabis. They were always already on good behaviour bonds when they got busted with their fresh crop. And so, as a general rule, we would say, that's fine. It's your partner's crop, it's the girlfriend, it's the wife, it's her crop this time. So the women would go along with that and go, yep, it's all mine, all those 400 plants, I've been doing it all by myself, my husband knew nothing about it. I was hiding it from him. And then they would say, well, that's great, so then they'd go before the courts, and I told them that what they had to do about a year after bust to sentence, was get pregnant and go before the court significantly pregnant, and then I could talk about Lindy Chamberlain and having babies dragged off you and whatever, and you wouldn't go to jail. So, and that worked a treat for literally dozens of women. The only problem was when I'd go to the markets or the Channon or anywhere like that, I'd be walking along with Maria, my wife, and women would come up to me and go, hey, this is little Johnny, you're responsible for little Johnny. And Maria would look at me like, I'd go, no, not like that. And I'd try and explain unsuccessfully. But so the tricks of the trade for keeping people out of jail are matters that we are really happy to talk about. That was one of them. Other ones that we talk about in the book and happy to answer questions on is where is it safest to store your stash in the house? What do you do if you're asked questions? Should you refuse a drug driving test? What should you say if you want to raise a defence of honest and reasonable mistake of fact? All those sorts of things we're really happy to talk about today, but being guided by you as to what topics or areas you want to cover.
I was about to say we need a microphone. The hall is a lovely place to be, but the acoustics are shocking, and you might be standing up and everyone around you can hear, but you can't be heard. So please use the microphone to ask questions. We have a roving one. Thank you.
I just wanted to say that you said that you shouldn't say anything to the police. Okay, so I was busted 7 years ago. I was researching it. So I couldn't bloody hold myself back when they came. I said, come in. This is the best medical marijuana system you'll have seen for a long time. I was supposed to go to jail for 33 years and 9 months, except that I gave myself up, so it was only 22 years and 6 months. And so the judge, Roy Ellis, smart man actually, I think, he said that Malcolm should be given a licence immediately to look after the terminally ill. And he said, don't you ever do it without a licence. Like that, with that big wink. And so I have been growing ever since. And the police helicopters go over the top of me, and the cop who arrested me said, Malcolm, when your name comes to the top, it's going to the bottom, and that's Australia-wide. I hope it's true, but I'm waiting for the police helicopters to land. And if they do, they're going to have a bloody hard time, because I have so much knowledge on this subject now that these guys, when they first busted me, they had 12 detectives in the room, and they all got on Google and they said, righto, smart ass, start talking. So when I started talking and they realised that I knew something, that was when things went arse over turkey for them, because they didn't know what I knew. This is the whole problem. Even in the courtroom, I told them they were a pack of retarded baboons, and I still didn't go to jail. These guys, Judge Roy Ellis, I think, is one of the smartest men that I've come across, and I congratulate you guys for doing what you do, and I hope that things slowly but surely get better. I don't know what's going to happen in the future, because I see a carrot is the same, get you stoned as cannabis does, right? If you eat it raw. So cannabis should not be described as a drug, it should be described as a vegetable. When you actually heat it, that's when you get a drug. So this is where I think we should be starting, is that it is a vegetable. End of story.
There's a lot there to talk about. I've seen things go well in courtrooms for those who speak out, and you are clearly one of those. But I've seen things go appallingly badly for those who speak out as well. Recently, a first offender possessing medicinal cannabis in 800 grams in Tenterfield was sentenced on a plea of guilty to 10 months jail for his first offence. He appealed to the Tamworth Supreme Court, Armidale District Court, and on appeal his sentence was overturned and he was given a good behaviour bond, but he spent 5 weeks in custody awaiting that appeal. So anyone who tells you that possession of cannabis or cultivation of cannabis for a first offence doesn't lead to jail is right in many cases, but sadly wrong in others. And similarly, those who speak out on drug law reform before the courts and before the police take a significant risk. And sometimes that risk comes off, but I think, I'd be interested to hear what Steve says, more often than not, it doesn't. And the advice not to say anything when apprehended is, at least in my view, holds true.
Two things really. A brief comment about what you're saying about the cop said you should have, be growing this and supplying the world with medicinal cannabis. The thought crossed my mind that Conservative governments love talking about cutting red tape and making things easier. Well, every year we have more red tape being cut. But to get a licence to grow medicinal cannabis, you've never seen. You can't understand how to understand the rules about the red tape you've got to go through. It's extraordinarily difficult. And that's been the law reform response has been so limited in terms of legal access to medicinal cannabis, getting a bit better, but being able to get licences and to produce a lawful product around these parts in particular, where there's all this expertise and experience, is just ridiculous. Generally, though, I think the biggest issue is what do you say when the cops turn up? And the problem is that it is a mixed bag, and lawyers are, we routinely say, no, don't say anything, don't say anything. If you unpack that a bit, if you're sure what you're going to say is going to keep you out of trouble, your decision, you go for it. But everything you say will be understood or misunderstood and used against you in court, if need be. So you've got to be absolutely sure of your ground. If you know for sure you can talk your way out of it, fine. Most people think they can talk their way out of it, and we see them in court. And they've been charged with something, and they've admitted something. They've said something they shouldn't have said. So many examples, sort of come to mind.
Appreciate it.
Absolutely respectful.
I acted for a young man in Kyogle who was charged, when I say young man, a child actually in legal terms, aged 16, who was found by the police with a bud of cannabis in his pocket. He said, the police said, you have to come to the police station. He brought his mum, and his mum said, look, just tell them the truth. If you tell them the truth, there's no problem. So the young man goes in there and he says, me and 3 or 4 other mates grew these plants, and they went right off, and there was other ones coming up, and we picked them all and we dried them all, and then we shared it all with our friends, and we smoked it, and we sold some, and we bought new skateboards, and blah, 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 blah. And by the time he came to see me, he was charged with possession of the bud and supply and cultivation and ongoing supply, which is more than 3 times, and he was seriously looking at being locked up because his mother had given him the advice, just tell him the truth. The better advice from mum, she was utterly mortified, she was a school teacher. The better advice would have been, say nothing, sign nothing, seek legal advice. And many years ago, when Steve and I were both at Redfern Legal Centre, there was actually a T-shirt that said, say nothing, sign nothing, seek legal advice. Still the best advice. The other thing that your question raised is and I can't remember what the proper term is, the compassionate cannabis scheme, which is,
Terminally illness, compassionate something, something like that, TICS, compassionate scheme, something like that.
So what there is this scheme which is hardly known to people, which is if let's say, if your loved one is dying, and certifiably dying, like not just like we all are, but actually has a disease that they are dying from, you are actually allowed to go and procure cannabis for them on the black market and sell it. And give it to your partner. You're not allowed to sell it. I don't know where that came from.
Steady on.
Take that back.
Can't do that.
I withdraw that, Your Honour. So you're not allowed, you're allowed to actually do that at police discretion. In other words, the police have a discretion not to charge you in those circumstances and generally won't. So there is this quite not well-known scheme that New South Wales government has, the police have, and as far as I know, they generally stick to it.
They do. Only a handful of people ever seem to access it. I guess the downside is, you leap of faith, you have to register with the police, so you've got to give them the details of your name and address and the dying person, etc. So, okay, I'm going to tell the cops something. But my experience is limited numbers, 50 or 60 people at a time, I think, are on it across the state. But yes, it works, and it's something that people should be more aware of. And sadly, for people who are in that facing that experience of their last days being numbered in that sense, could and should take advantage of that, and their carers. That's the
Mind you, it's quite hysterical when you think about it, that they actually allow people to purchase this from the black market. This isn't going to a doctor and getting a prescription. This is actually saying you can go and get it. Now, I don't know where you're meant to do that. Presumably, the lane boys will help you out down the road here, but other than that, it's an amusing scheme.
It's the Terminally Ill Compassionate Scheme or something like that. TICS is in my head as the initials, the acronym for it.
I think Alex had a question up the front here.
First, I'd like to make a brief comment and thank both of you for fighting the good fight so hard and for so long, and I can't not include Michael Balderston in that same comment. We're all enormously grateful to you for this. It's a difficult battle, as you well know, and we just need to keep on fighting and never giving up. But I had a specific question, it may be inappropriate under the circumstances, and that is, it's really 2 questions, and they bear on the constitutional law aspects of this. and that is to what extent, if at all, can we expect a state or a territory to undertake independent reforms, and that includes also the question of generating government revenue through taxation of cannabis, bearing in mind the High Court decisions relating to alcohol and tobacco in, I think, 1997. So that's the first question. Second question, which is related to that, is to what extent, if at all, can the territories, ACT and Northern Territory, make significant reforms without fearing a Commonwealth overruling that those reforms cannot take place?
I can answer the second question first, and then you can answer the first question because I can't remember it. Okay, so the states and territories, I mean, we do have an island of sanity in a sea of shit, which is the ACT, where they have really gone out on a limb and passed legislation in their own parliament to effectively legalise cannabis. This is a very good thing. Mind you, they haven't changed the drug driving laws, but we're getting there. But they are beholden entirely to the whims of Commonwealth Parliament, which can overrule them on this in a flash. We saw that most notably with euthanasia in the Northern Territory, where it existed, and I think a few people managed to take advantage of it before the Commonwealth Government exercised their Christian right-wing views and overrode it. And the same could happen in the ACT at any time. I'm surprised, I thought it would. I'm delighted and surprised that it hasn't, and I think it augurs well for the future that it hasn't. I mean, Scott Morrison is hardly, and if he, as an individual, decided they were going to try and overrule it, I'm sure that they could get the numbers, or you'd think they could get the numbers in the lower house and probably in the upper house to overrule it and do so rapidly. But they haven't, and they haven't even tried to. So what we've got is the Northern Territory as some sort of guiding beacon where you can grow, I think, 2 plants. People down there tell me the biggest problem, though, is you're not allowed to grow them indoors. So, of course, growing anything in Canberra is really tough. Growing cannabis, which is, you know, a North Coast tropical plant, is really difficult. And, of course, it encourages theft because you finally get the plants to grow in the few weeks of warm weather that you get in Canberra, and then bingo, someone nicks your crop. But apart from that, it's interesting to note the sky has not fallen in there. We haven't had, you know, mad people ripping off their clothes in the street and throwing themselves through plate glass windows. It'll be very interesting to see their figures. There's a research project on increase or decrease of youth use of cannabis in the ACT. They're due to report through the Australian Catholic Edith Cowan University, and they're due to report in a matter of months, and it'll be really interesting. And I bet it shows exactly what Portugal, South Africa, those states, the United States show, that there's no increase in young people just because it's been legalised. But the Northern Territory has better laws, a bit more decriminalised, but still not good, and haven't been overridden either. So it really is going to take one state to break loose, because the Commonwealth can't override a state on that unless they try and rely on some international treaty. Now, the fear was with cannabis that they would. We all remember Tasmanian dams, and the Commonwealth was able to override the state wanting to build the dam because of an international treaty about protecting World Heritage areas. So there were international treaties that involved cannabis, and they were led by, you interrupt me if I get anything wrong, won't you? They were led by the Americans, like pushing hard for it to be declared and called a narcotic and not allowing any. For many years, the UN and all the conventions and all the rest had cannabis boogeyman bad. But now, of course, America's gone rogue, and allowing medicinal cannabis and legalising cannabis in various places and in various states, and all these other countries like Thailand and South Africa all have legalised cannabis, and so the whole international boogeyman cannabis has died off. And I don't think the Commonwealth now could successfully override any state that decided to legalise or decriminalise cannabis. That's the answer to the state and territory question, I think.
The ACT, there's some early figures about ACT hospital admissions and so on in terms of people turning up with any kind of cannabis issue. The drug testing numbers the early figures showed no real difference at all in people's behaviour, which is again, David said there's more detailed study looking into Canberra, the ACT, so that's kind of interesting, I reckon. What was the first question again? Sorry, that was such a long answer, I have to say.
So the first question was, to what extent can the states act independently without
Sure.
in cannabis law reform?
And it is related, of course.
David's not correct about the United States going rogue, because the international treaties are between the parties, and the parties are nations, not states of nations.
No,
so
that's
the
right.
17 states are not haven't breached that.
Yep.
That's right. The state of New South Wales is not a party to any international treaty and not bound in any sense. Politically, they talk as if they are generally, but anyway. No, it's an unfolding and interesting area. Constitutionally speaking, the powers between state and federal government are divided up. So the Commonwealth has powers in certain areas. Other things are left to the states. If it's silent, the states are responsible. Drug law has generally been seen as a criminal issue because that's what's self-defining, I suppose, police issue. So the states have got the ability and authority to make powers about policing, generally speaking. So that's the sort of broad constitutional issue. The other point about Canberra, I remember, is that before I forget, is there's a federal law about possession of cannabis and supply of cannabis and so on. It's just never prosecuted. There's a federal law that says thou shalt not do this, this and this and this. It's the state law that's always used in court to charge people. In the ACT, the federal police, who are there all the time because it's Canberra, could arrest people if they see someone smoking a joint or whatever, and they have not been doing that. So they could use the federal law, even though the territory law is no longer makes it illegal. They could use that federal law, but they are not using that. So that's also an interesting insight into the government's thinking. But yeah, so broadly speaking, the powers are divided. Sometimes the broad history of constitutional law over the last century or so is creeping federal power, more and more power going to the Commonwealth. Bit up and down, but that's the broad trend. Commonwealth can use international treaties, as David was talking about before, to sort of widen its constitutional reach, but there's been no evidence of political appetite to do that around so far.
Yeah, and what Alex says is correct. America has not gone rogue. A lot of the states have, but what I mean is they also haven't exercised, the American government has not exercised its power over either its states to override their changes to the drug laws so far, and I doubt they will under the current regime, but also they haven't been agitating in the same way that they were about cannabis internationally.
My tip, Matt Keane becomes the next Premier of New South Wales, introduces drug law reform in the next term of Parliament.
Wow.
Big call.
I've been hearing this optimistic drivel all for the last 30 years, next year in Mecca, sure.
New South Wales does it. The ongoing, endless federal Conservative government doesn't intervene to stop them. That's my big tip, tip.
That's great. My big tip is that Kate Furman, who's here, is the next Premier of New South Wales, and we have drug law reform really quickly.
Perhaps another question.
Any other questions? Yes?
Okay. First of all, I'm not from New South Wales. We're from
Put the right close.
Right close, okay. I'm not from New South Wales, I'm from Queensland, so I'm not too sure how the laws differ. But I'd like to know more about the not so much the medical prescriptions, but the, I suppose, black market hemp oils that we're using. Grown legally under New South Wales licence, they get tested for less than 0.03 THC. Can we still get caught drug driving with that? And there's a lot of old people that are on it, and they're all really scared to go on the prescription drug because now they go the 10-10 with THC. So basically, how do we stand?
I think the short answer is yes. Can you still get apprehended for having any THC in your system? Yes, and I see Tom is here from Drive Change. And we'll be talking about this in a big session tonight at 6 o'clock with me, Tom, Alex, Wodak, and a few others on the drug driving stuff, but I'll answer it briefly now because it's a good question. So there's actually a mistake in the question, if I can point this out, because even if you were using the THC under a prescription, or even if you were using the THC because it was part of the new program where you can buy it over the counter from a chemist, it doesn't matter how even if the THC is in your system because you
smoked it in Canberra and you flew to Brisbane.
Yes, you smoked it in Canberra and you flew to Brisbane, or you smoked it in Portugal a few days ago or pre-COVID. It doesn't matter how it got into your system. If it's in your system, you're guilty. If I had $1 for every person who said to me, but I've got a prescription, I keep it in the glove box, and then when the policeman pulls me over on the way to MardiGrass, I can say, it doesn't matter if I test positive because I've got a prescription for it. Doesn't matter. It's no defence. And it's no defence in New South Wales, it's no defence in Queensland. If you're found with a minute quantity in New South Wales, the test cut-off is 5 nanograms, that's 5,000 millionth of a gram in your saliva, then you lose your licence.
So that's even less than the legal amount that they sell in the hemp?
Okay, so if you buy on the black market anything, then it is likely to contain THC. You can buy through prescription CBD isolate, which has no THC in it. But if you have any THC in the medicine that you are using, you are risking losing your licence. If you take it as prescribed, and for most people, I think that is taking it daily or more than, how often are you prescribed, for example?
No.
Every day or whatever, then you are likely to have THC in your system all of the time and enough to be tested positive. Anything to add to that, Steve?
The only softening bit is you can go to court, magistrate sometimes will use their discretion to not impose a conviction. In New South Wales, the figures are pretty high, as in probably more than half people facing the charge who go before the courts are given the benefit of that provision, I suppose. So you don't get a conviction, you don't pay a fine, and you don't lose your licence. The downside is, once in 5 years, is that power available to the magistrate. So you get busted once, okay, you've got a good record. 2 days ago I had the smoke your honour, leave my car for this reason, this reason, this reason. All very excellent reasons why you should be allowed to continue to drive and avoid any criminal punishment, but only available once, effectively speaking. So that's a real problem, I reckon, in terms of any softening of the impact of the laws in terms of what the courts are able to do, some limited ability to intervene, but basically it's a very, very simple enough process. If it's present in your system, guilty of the offence.
And in some states, they suspend your licence as soon as you're apprehended. So, in other words, you've got time off the road before you can get to court. And for some people, that means no job, no everything. So, there is, and in some states, the magistrates, Victoria, don't have a discretion for you to keep your licence, even if they don't convict you. So, it's a bit of a mess. The only option is to move to Tasmania, where if you have a prescription, it is a defence to drug driving, as long as you're not weaving all over the road and driving while under the influence. Tasmania, miraculously, I think accidentally, has a provision. Funnily enough, in New South Wales, we do have a provision for an illicit drug. If it's in your system, you're not guilty of driving with morphine in your system. And that's been in place since the 70s or something weird. So there you go. But not cannabis, not THC. So if you're in Queensland, whether you're on a prescription or not, if you've got THC, too bad.
Just the other really quick thing about the New South Wales law. These days, if you're a first offender, as in a good driving record, and the first time you test positive, you get a ticket in the mail, $590-something, I'm not quite sure the amount, 500 and something, and a suspension of your licence for 3 months. So that's what's happening now. The government looked at those stats about how many magistrates were being generous, how much of the time, and thought, what we'll do is we'll make it a fine-only offence, not on your criminal record, so you pay the fine, you don't get a criminal. It's not on your driving record, well, not on your court-to-court record, sort of doesn't matter really. You don't have to go to court though. You pay the fine, you lose your licence. You can choose to go to court and the magistrate will take account of all those circumstances. So people need to know that if you're unlucky enough to be testing positive to THC, driving around doing nothing, minding your own business, and you get that ticket, you can choose to go to court and put your circumstances to the magistrate.
And yes, if you, my opinion is that these provisions that Steve just mentioned are specifically a reaction to magistrates being, quote, too lenient, end quote, on drug driving. When I was a magistrate and I started speaking out about these in judgments, appropriately in court, being appalled by this and saying that it was ridiculous, and particularly the advice on the road safety websites. At first it said you could use after 12 hours, then 24, now it just says a time. So I started speaking out of it. Universally, other magistrates were saying, well, I just deal with it by way of Section 10. I just give everyone back their licence for this stupid offence. So instead, and Parliament doesn't like being told that they're being stupid by magistrates, so they made it, as Steve says, so that there's sort of the first position is you do lose your licence for that period of time, taking discretion away from the courts. That of course was never my intention. Yes.
Thank you both for your time. My question's in regards to the roadside drug testing, and for some of our interstate guests. If they're done on a roadside drug test in New South Wales, however, carry a licence from another state, under what law are they processed?
If the offence occurs in New South Wales, it's a New South Wales offence, so dealt with by way of that ticket or in a court in New South Wales. If you lose your licence in New South Wales, you lose your licence in every other state. Okay, so there's mutual laws basically in all the states to say if someone's lost their licence in another state, also not entitled to drive in this state.
Okay. And one more question. In regards to the roadside drug testing, is there independent studies showing the efficaciousness of the preliminary roadside drug test, and where would we find that information if someone wanted to look into that?
There is some good research. It's funnily enough, if you talk to Michael, they've tried to do their own research here, which has involved, hysterical use of cannabis, doing the drug test, and they will tell you that this is with the first test. So there's 3 stages. There's the lick stick, then there's the Dragar test, and then it goes away to the laboratory. So the Hemp Embassy did some exploration with the first test, and they found that it was completely inconsistent. People could smoke a joint, do the test, and not test positive, and other times they would, and sometimes after 10 minutes. And so there's a great deal of inconsistency. There's a great scientific study for you. But the better studies are ones that, for example, have been done by the Langford Institute at Sydney University. And if you Google Langford Institute, Sydney University. But of much more interest to me, and I'll be talking about this, or maybe now's a fine time to talk about it, and that is that there is absolutely no evidence, not one iota of evidence, that the 225,000 tests in New South Wales have reduced the road toll at all. It was shown when they brought in random alcohol testing, massive drop-off of the road toll. Same with seatbelts, airbags, 50-kilometre-an-hour speed limits. All of those had a direct, clear impact on road trauma, deaths and injuries. Nothing by the introduction of all of this pain. So it's all pain, no gain. Now, the stats that are often thrown up is this. 15% of those who are engaged, who are killed in motor vehicle accidents or have illicit drugs in their system. When you dig down on those figures, it shows this, and I'll just use South Australia as an example. Are we bored, or is this interesting to people? Okay, so in South Australia, they took all the dead people for a few years who died in motor vehicle accidents and did blood tests, and yes, 15% of those had illicit drugs in their system. 6% had THC. So, first thing to note is it was a 2 nanogram test. Remember I said 5 nanograms for drug driving? 2 nanograms. Nobody in any sense of reality says that 2 nanograms is a problem. We're talking residual low-level use. Second problem with that figure is that nobody is suggesting that those with the 6% caused the motor vehicle accident. Like, they might have been pulling out and going to overtake, someone else might have hit them head on. They might have been in a single motor vehicle accident. They might have been a passenger. So nobody is actually suggesting there's a causation relationship between that 6% and motor vehicle deaths. Further, if you look at the cohort of people who are involved in motor vehicle deaths, the age range that is massively overrepresented is 18 to 25. And we all know why that is. Now, if you look at the actual number of 18 to 25-year-olds in South Australia who've used cannabis in the last 12 months, I'm not suggesting that that would stain your blood for 12 months, but that's the only figure available, it's way over 6%. So in fact, this number that, 15% have illicit drugs in their system, that may be true, but what it is a classic example of is confusing correlation with causation. In other words, there is 6% of those people who have less than 2 nanograms. But nobody, even those in the research done on this, the papers done on this, say that that is the cause. Clearly it's not the cause of these deaths. And it's such a huge gap. So there is no relationship between this testing and road safety. And it's not really, I think the reliability of the testing is a little bit of a furphy, because the truth is, if it doesn't work to reduce the road toll, then what in the hell are we doing it for? Anyway, more on that at length at 6 o'clock tonight.
Probably another question, but I can't resist the anecdotal sort of war story. David and I had a case together. I was the defence lawyer and David was the magistrate. We had a regular appearance from an expert witness for the police, Dr. Judith Pearl, who was the pharmacologist basically wheeled out by the prosecution in case after case after case to explain the science behind the testing, etc., etc. We were challenging certain things and she would explain certain things. But at one stage, we got quite friendly. We got sort of quite, as we went through a series of cases, we got a bit more chatty. That's just not working. Oh, yeah. That's working better now. Anyway, at one stage, she just sort of gave this long answer, and Dave and I think, both just sat back and let her talk. And she said, look, I was on the committee when we were talking about, the government was talking about introducing this law, and I said, oh, look, I was against it. I said, Judith Pearl, was against it, because it's nothing about impairment, nothing about road safety. And the rest of the committee said, no, it's about reducing cannabis use. And that was on oath in the local court at Lismore from a member of the expert panel that was advising the government whether they should or should not introduce this law. That was her evidence, that her personal view was a waste of time, but that the committee recommended to government and the government accepted that recommendation.
Yes, she also said, can we rave about this a bit more? Or are we getting lots of... She also said that, that there was no transfer from blood to saliva. This is incredibly interesting, and I then asked her, well, if somebody took the cannabis as a suppository, would it possibly be able to get into their saliva? And she said no. And then I asked her, well, what about a capsule? like a capsule with oil in it that you swallow. And she said, well, possibly if you vomited or had an ulcer in your mouth or if you burped, possibly, but much less chance. So it is a saliva test, not a... I'm not suggesting... I could just imagine all these people having cannabis parties where it wasn't pass the joint, it was just drop your dax.
No comment.
Another
Hi,
question
guys.
quickly. My name's Scott, I just live up the road. I'm a prescribed medicinal cannabis user, and I've got off the opiates, but my question is in relation to possession and use. Like, I go out of the house, I move around, my pain issues kick in, and I light up a joint. Now, I'm carrying cannabis on the street, I've got a photo of my prescription, but when I ask my specialists and doctors, everyone, no one can tell me where I stand with carrying the cannabis, and yeah, I'm quite happy to have the drug dogs go past me, but I don't know what's going to happen once that actually occurs, and no one seems to know.
Are you prescribed flour?
I'm prescribed flour and oil. Yeah.
Well, if what you are possessing and using, they're separate offences, is consistent with your prescription, then should have no problem. You might have some difficulty talking to the cops about it and so on, but there should be no real legal problem in terms of certainly being found not guilty and possibly and probably should be not charged, as in not to go through the process. If you do not have a prescription, the possession of cannabis is an offence. The use of, if they see you smoking a joint, you could be charged with the use of cannabis. That's very rarely prosecuted these days. Sorry, I'm sagging. Very rarely prosecuted these days, but it is technically officially an offence. If it's less than 15 grams, there's a discretion to give you a caution instead of taking you to court. So again, without a prescription, less than 15 grams in possession, you should get a caution if you're a first offender. Okay. Limited otherwise.
On that with use in public, because you can go out and you can take OxyContin in the car, not a problem, but really you're not supposed to light up in public.
It's a legal problem. It's still a legal problem, smoking in your car.
Oh, okay.
And a car can be a public place. If you're in the street smoking this joint in your car, it's in a public place, legally speaking. But it doesn't matter. There's no offence. It's no extra offence to smoke in public. It's the possession of the drug or the use of the drug in public or private. Doesn't matter.
Right. So you are permitted to do what you're doing. I recommend that people actually do carry their prescription with them. They get them, what's that called, where you get the plastic on both sides of things?
Laminating.
Thank you. You laminate it and you stick it in your, you make sure that you've got it accessible at all times. In the time that I was a magistrate, I never saw anyone charged with possession or use who had a prescription for it, unless it wasn't the substance that was prescribed. So you've got to be careful with this. And that is, I don't know how they can tell scientifically, right? I mean, you get it from the chemist or you get it from your mate. But technically you are guilty of possession and self-administration, the use, if you're not using the stuff that you were prescribed. And you need to be cautious of that.
Yep. All right. Thanks.
Just a follow-up question on that. The TGA guidelines state that you're only allowed to vaporize your cannabis. So how does that impact if you're smoking a joint?
I did not know that.
I did not know that. Tom knows everything, but no, he does. So Tom's from Honolulu, which is a cannabis... you can tell them what it is, Tom.
Yep, so Honolulu, you can go to honolulu.com.au. We're a cannabis education platform. I know I don't sound Australian, but I am. And we focus our education on, right now, particularly medicinal cannabis and the laws and regulations in Australia. So you can find everything about how to access it legally, employee rights, kind of a broad range of anything you might want to know. And if you have further questions, you can always send them through. And we work with people like David to get you those answers. So that's the only reason I asked that question. I haven't been able to find a straight answer on that either, versus the smoking versus the vaporizing. But the TGA guidelines do say that it's only permitted for vaporization, so just be careful with that.
I still would maintain that you're not guilty of the offence because you've got the prescription. It'll be an interesting test case when they arrest you, and Steve's your man.
hard to see with the light in our eyes. Is there a...
I've got a problem.
Microphone, please.
I've got complex PTSD, okay, so I study the subject to try and figure out what I can do about it. And when I look at all of these psychologists, psychiatrists, they're telling me that all addiction comes from childhood trauma. And I had no doubt childhood trauma with a father who went away as a perfect gentleman, came back from the war as an absolute arsehole and destroyed my life, along with others. So now I look at this thing and I wonder how the judiciary are looking at, you understand what I'm asking, don't you?
Yeah, sure.
Yeah.
Look, and books like Chasing the Scream were an absolute revelation to me. And I read it while I was a magistrate. And I sent around an email to all magistrates, which was, not the done thing, saying everyone really has to read this book, because it's a brilliant book because it is so readable. But yes, the gateway drug to addiction is not cannabis; it's trauma, and as I say, it's a revolution. I think the tide is turning. Slowly, in the judiciary. Just one little example. There used to be a rule that if you supplied drugs for profit, you went to jail. This was a rule created in the 80s, I think. It wasn't a rule set by Parliament. It wasn't no minimum term, but the general rule was established by the courts over years. Perhaps 2-3 years ago, that rule was just thrown out. Said, no, that's just not true. It's not that simple. Often people are supplying for profit because they're addicts or because they're using or for whatever sorts of reasons. That's the path of life they've chosen, and it's not automatic jail. Now, that is a big change. Secondly, there was a leading case called Morga, which was upheld by the Court of Criminal Appeal, and it's a really important decision. I'll just run through the circumstances briefly. In that case, a man in his late 20s, early 30s was found to be in possession of 25 ecstasy tablets that he said he was going to supply to his friends at a festival. He wasn't going to sell it, or he hadn't actually thought about whether he was going to sell it or not. He was of two minds, but that was the evidence. So he pleaded guilty to possession of the 25 tablets of cannabis and possession for the purpose of supply, so supply to his friends. He was dealt with at first instance, that's by the district court because of the number of tablets, by way of Section 10. In other words, he was given no conviction, no fine, no criminal record, no penalty, and a good behaviour bond for 12 months. The prosecution were outraged by this decision of the district court judge and appealed to the full Court of Criminal Appeal. That's the highest criminal court in the state. 3 judges of the Court of Criminal Appeal, 2 of them ex-prosecutors, determined that this was a test case, that this was a case that was being appealed so that the highest court in the land could give its verdict on whether this was an appropriate or an inappropriate penalty for this offence. And they unanimously said it was appropriate. So that is an absolute sea change. Now, sadly, there are magistrates and judges about who don't follow the clear directive, the clear direction of the Court of Criminal Appeal and still continue to give people who are charged with way less. I gave the example earlier today of a man in Tenterfield who was given 10 months imprisonment for possession of 800 grams. That's not supply, that's possession for his own use. There are magistrates who are so bloody minded, they think, well, I'll do what I want, what I believe. I'm not going to have the Court of Criminal Appeal tell me what to do. But hopefully they're the rogue, not the norm, and I think things are slowly changing for the better. But it's a slow change and there's many bumps along the way. So the short answer is I think the judiciary does recognise that drugs are a health problem, not a legal problem, but it's taking us a long time to get there. Steve?
Generally speaking, sentencing is one of those dark arts that takes account of, judges are meant to take account of all sorts of issues, the circumstances of the offending and the personal circumstances of the offender. Rehabilitation is part of it, punishment's part of it, so it's a bit of a difficult thing to be sort of simplistic about, I suppose. But broadly speaking, yes, the personal circumstances of any offender on any offence in terms of mental health, traumatic background, PTSD, diagnosis and so on, would always be relevant. I agree with David. I think there is a broad change towards lessening the penalties for drug offences that were historically seen as quite serious offences are now seen as not quite so serious in terms of the inevitability of jail, which is something. But there's still a lot of people going to jail, a lot of policing and a lot of people before the courts every year charged with possession offences and very minor offences. Trying to work out this microphone.
Just speak into the microphone.
Just talk into it, I know. It's not that hard.
Yeah. Hope that answers the question.
It does.
Further questions?
Yes. Thank you. With regards to, you said before, Section 10, it can be wiped away. My question is it wiped away? I saw the article the other day about 5,500 people who were roadside drug tested, found nothing, but they're in the police database and they're available to the broader database. So what happens on a Section 10?
Okay. It's a difficult and confusing area that has a lot of grey. There are three kinds of records. There is a court record, there is a police record, and there is a criminal record. If you are drug tested, there is a criminal record. If you are drug there is a police record of that. You're on a database for having been tested. The licence is scanned or notice is taken of it. If you are charged with that offence and dealt with by way of Section 10, you don't have a criminal record, but there is a court record of that, and of course there is also a police record of that. So that, just by way of example, there is a fellow in Sydney who is being very well and actively represented by Mark Davis. He ran a security company. I say ran because he was dealt with by way of drug driving, got a Section 10 for it. 3 days later, whatever arm of government deals with security licences suspended his security, actually cancelled his security licence because he had admitted to a drug-related offence. He had 30, 40 employees. It was a business he'd built up all his life. Gone. Further, if you are drug driving and you are insured with AMI, it says, the AMI policy says, if you have any illicit drug in your blood, saliva, blah, 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 above the legal limit, you are not covered by your insurance. I'm paraphrasing, but that's basically what it says. Now, what that means, what is the legal limit for THC? Well, it's 0. So it doesn't matter if it's 2 nanograms, 5 nanograms, 10, or in Balderstone's case, several thousand, 270,000, something like that.
Off the scale.
Yeah, like his case was just a rocket, but it doesn't really matter because if you're driving a nice shiny Merc, then you're stuffed. So yes, the criminal record issue is everyone focuses on, will I have a criminal record, won't I? You still have a police record, and often with a Section 10 you still have a court record. It'll always come up on the court record if someone's had a Section 10 before because of what Steve said. You can't get 2 in 5 years. So, yeah.
I think the confusion comes from the phrase no conviction recorded. People, I think, seem to think that there's no record, it's just sort of forgotten about. It's recorded, but as no conviction. The other thing to say about the policing process is all highway patrols these days have these clever cameras on their grills and so on, and in-car computers. So if the police database shows that you have tested positive to THC before, a little light will flash on as the highway patrol drives past you, and the officer may well do a U-turn and pull you over and test you again. We've had people who've been tested multiple times. One poor woman who got the car from her boyfriend, he tested positive, but she didn't. She was tested about 7 times, I think, in 3 months because of that. She passed it every single time. She was not a user herself, but not real happy about being stopped so many times and being tested so routinely. But it's something to be aware of there in terms of the policing. They know, and they can magically know as they drive past you that you might be someone who's fallen foul before. I can't remember. I've had it described to me by clients who've had a ride in police cars for various reasons, who describe it going off in their way to the bus or the station, but I can't remember the details.
There's a special light that goes off if you've ever attended at Nimbin Town Hall,
yes,
legal advice session. So you guys are all fucked now.
Gone. Any other hands? Any other? We can go on and on because we're lawyers. We'll talk forever if you let us, but we can also stop as well.
Hello.
Yes, please.
I'm not sure if it's relevant or the right time, but I heard a rumour, I was just interested if you may know, that the people who own the company that make the drug test kits are police.
It's
Is it possible that they could have a vested interest?
I think we have someone here who did some research on this.
Andrew Cavasilis is the source of this particular...
In this particular rumour. Steve and I have both looked into this.
Have we? The people, the company who first brought the Securitech device to Victoria were 2 ex-police officers, Victorian police officers. So there is a connection with the police. How much that... Andrew is... full bottle on this, he'll talk to you in great detail about the connections, but that's my understanding, there was that original connection.
Thank you. And the kits, they cost $100 a go? Is that
about $40-45 a go, I think, for the swab.
The very interesting thing to me about it is, yes, of course that's important. Someone is making a shitload of money out of all of these tests. Let's be clear on that. What is interesting in New South Wales, and I suspect around Australia, is where this money comes from. The money to fund these tests, not just the test kit themselves, but actually also to pay the police to do it, is road safety money. In other words, this is money that's meant to be spent on guards and education campaigns and better roads and black spot programs and all potholes. Potholes is funny. That's funny. Potholes. I like it. I'm going to use that from now on, and I'm going to claim it as my own. They should be fixing potholes rather than potheads. But the short answer is that that money is road safety money that gets paid to the police to administer the tests. I don't know the amount the police get paid, but let's make it clear there is a vested interest in the police budget at continuing to administer these tests. It assists them by increasing their money. Money is power, money is more police, etc., etc. That to me is extraordinarily interesting and concerning. So yes, the owners are making money, but there is another agenda here, and that is that the police, I'm not saying individual police of course, but the police service budget grows by administering these tests.
Who do we kill?
Well, I mean, where it's a really important question. Where and how do we affect change? And this evening, I think we have David Shoebridge, Tom, who you just met, Alex Wodak. Steve, are you on that panel?
Yes, I am.
And I won't let Steve talk much because I'm facilitating it. But really, 6 o'clock tonight, and I mean, I'm happy to address it now very briefly. Who do we kill? How do we really affect this change? And the answer is, of course, it's the politicians. You know, this is a law that is capable of change at the strike of a pen with no increase in death toll or road toll. So, you know, the question is who wins out of this? Pharmaceutical companies win because people are taking pharmaceutical drugs. The alcohol industry wins because it keeps its monopoly on mind-altering substances. The police win because their budget increases. Pharmaceuticals alcohol, biggest donors to political parties in New South Wales. You do the math. So, in essence, it's the politicians. I'm not suggesting we kill them, but I get the point.
Hi. I just have a question. I have a friend who has medicinal cannabis for her problems. She told me that she keeps apple cider vinegar in the car and she swigs that in the case that she's ever pulled over. Is that true? Does that actually do anything or not?
Would love to know the answer to that question, and I'd charge people to give them the advice. Don't know. There's a lot of people who say that it works, a lot of people who say it probably didn't, a whole lot of other fisherman friend lollies, chocolate milk, some people say, a whole lot of folk remedies about how to avoid testing positive. Good oral hygiene seems to be high on the list, so brush your teeth every day, you should do that of course, but mouthwash, Listerine and so on. Brush your tongue as well as your gums, as well as your teeth. Keep your, clear out as much saliva as you can seems to be the best broad advice. But masking such as apple cider vinegar, 4 or 5 or 6 other things have been floated. Maybe they work, maybe they don't. It does seem random. Random not in the sense of, random in the sense of sometimes people are positive, sometimes they're not. If you've had a smoke in the last hour, you're going to test positive, I reckon. If you've had a smoke yesterday, you might not. Thank you.
Is that Gerald?
From the testing that we did with the lick testing, there was as many positive readings from people that hadn't used any cannabis as there was from the people that had. So it doesn't really matter that much whether you've cleaned your mouth out or whether you haven't smoked or whether you have smoked. It's very random. The whole thing's really quite random.
The good news is if the randomness falls in your favour, that's great. You drive on and carry on with your day. The swab, the initial swab that we're talking about, the one that the embassy, I remember that famous afternoon where that 20 volunteers, brave volunteers, consumed some cannabis and some of them didn't. The braver ones went without cannabis for a day to see if they would test positive. Very brave, those people. I know. But the first swab is not the basis for the charge. It's just a screen, an indicator. So they swab your mouth, your tongue. If it's like the pregnancy kit thing, if the line shows up, that indicates that you have a drug in your system. THC, cocaine.
Either that or you're pregnant.
Or you're pregnant. Then if the line shows up to the officer's satisfaction, and I agree looking at them on that particular day, it was a bit hard to tell in the sun and so on. What is this? Is this a line or not a line? Anyway, so it doesn't matter. If they let you go, great, they let you go. If they don't let you go, then it's what they take at the sample they take at the police station or the bus that is the basis for the charge. The second stage is simply putting it in a machine, unreliable as all get out. If you test positive at the Dragar machine at the second stage, you are told not to drive for 24 hours. If you test negative at the Dragar stage, you're allowed to go. But that sample that they put into the Dragar machine and taken out is sent down to Lidcombe to the laboratory. If that is tested positive, you get the charge. 95% or more are positive at the lab. Whatever the middle test says. Half of them at the middle go home. Negative. Or a false hope given to people who survive that test who are allowed to get a ticket.
I just can't help myself adding to that just briefly and saying that sitting on the bench, there was never any forensic delay in getting those tests back. That is, the tests back from the lab. Compare that to delay in getting tests back on DNA swabs in sexual assault cases, which was often months and months in getting them back. And it said to me a lot about government priorities when drug driving testing swabs were returned rapidly, but those involving really serious crime were not.
Priorities.
Hi. Also, hydrogen peroxide, 3.5%. Supposedly that cleans your tongue. But, and in fact, the other day when I was I was in Lismore, and I knew there was drug side testing. I went into the police station, and I requested to be tested, but of course they refused. Yeah. So, but someone else said that they can't refuse it, or there's some kind of legal thing if they refuse, and you drive. Apparently, you know, you wouldn't be liable. But anyway, what do you think is the story?
I've not heard that before, and I doubt it. I think that if you go into the police station and say, test me, and they go away, and then you drive and you're apprehended and test positive, I don't really think you're going to have a defence by saying, well, I went there and I was tested. In fact, it makes some defences harder. For example, an honest and reasonable mistake of fact that you had in your system would be unmaintainable in circumstances where you had enough suspicion that you might test positive to ask to be tested. So I don't think it's a defence, and I think it might take away some defences. Steve?
The police attitude to those kind of requests for testing without being a driver is that, no, we're not going to do it. We don't want to, we don't have to. But also I think the logic is if they test you and you're negative and then you drive sometime later, how is anyone to know what you've done between the test and the driving? So it's creating all sorts of false narratives possibly about whether or not you've consumed any drugs in the meantime. So they just don't want to get involved in terms of having to go to court to say, well, yeah, at 12:30 it was okay, 1:30, you know, what does that mean really? So anyway.
I was going to say it's 11:15. Sorry, it's misguidance over here. So I reckon, guys, maybe it was like a voice from... Anyway, I reckon maybe one or two more questions and then that's it, and we'll get ready for Professor Kylie O'Brien, the next speaker. You need the microphone, my darling. Please wait.
I'm going to sing a song then. Woo! I just wanted to ask... In reference to that question, were you asking actually the police to test you just to test whether your hydrogen peroxide 3.5% worked, or whether you could drive? I mean, what was the game there?
My game was actually I'd had a black coffee and I'd had some oranges and I'd had some hydrogen peroxide. So I was trying to see if my tongue was clean.
Yeah. I wonder if you'd have offered them $50 to do the test.
I did offer to pay, but they didn't want to take my money. So anyway.
No, well, I'd been thinking the same thing today, actually, that I might try that, but I won't.
Yeah.
Yeah, that's all. I just wanted to clarify the question.
There is a huge market for people to test themselves for alcohol. As we all know, it's a multi-billion-dollar industry for people to be able to check themselves, whether it's at pubs or clubs or at home, but before they drive, taking a test. And they're now moderately accurate, at least enough to see, to get a reading. It'll be great when that happens with THC, but my understanding is the technology of levels in your saliva is so random and so, it can be a different person's acidic body levels on certain days can vary it. So it's going to be pretty hard if you test clear 1 minute, even if you don't smoke or have a top-up in the meantime, you still might test positive a few hours later. So it's going to be a long time coming. In some states in America, they use a program called Druid, which is the police use it to test whether people are impaired or not. You have to stand. You hold your iPhone and you stand on one leg and you push buttons and follow the little thing around. Tom and I both did it. It was exciting. It was fun. I was straight, and I was clearly able to drive.
One more question up here. Hi, I'm just wondering if the consumption of THCA, for instance, and knowing consumption of THCA, and whether that would give you a positive reading for a drug swab, and then whether that could be used as a defence, because even though you're knowingly taking it, it's not creating impairment.
So, someone will correct me where I go wrong. Dolph, if he's here, is a world expert on THCA. He's not. Okay, so there are people around who sell THCA as a medicine. THCA does not trigger, theoretically, the THC reading in the tests because it hasn't got acid in it. But if you leave your THCA in the glove box when you're a fly-in, fly-out worker, and then you come back, it may well be that you then use it and you can be tested positive because the heat effect on the THCA, which is the raw THC, it creates the chemical change that means that you can still be tested. That's the first part of the answer to that, I think. Is that correct to your knowledge?
The offence is to drive with the presence of THC. So THCA is, just to be clear, is not part of the legislation. Other cannabinoids, CBD, etc., are not part of not part of the offence. So it's THC only. I'm no kind of scientist, but I thought the THCA converted to THC on ingestion, as in. Alex or someone might be able to correct us pretty easily, but medical advice from a lawyer is always as good as it sounds, so I'm not really sure about that.
But the short answer to your question is, if you have THC in your system, whether it's from consuming THC that's been hot or for any reason, you are, on the face of it, guilty of the offence. Would you possibly have a defence if you believed you were taking THCA? I'll use this as a simpler example. If I believed I was taking CBD isolate with no THC in it, I had a prescription from my doctor who said this does not contain THC, and I just took the CBD, and I got caught because for whatever reason there was THC, then you would potentially have a defence of honest and reasonable mistake of fact. I honestly didn't believe and reasonably didn't believe that I had THC in my system. Same could apply with THCA. But it's a long road to go down that defence. Steve's run probably, 20?
Not quite that many, but a few, certainly a few.
Yeah.
Hey guys, we're running out of time. We'll do you, and then you've got a question, and that's it. If you guys want to continue discussions with these incredible gentlemen, you can do it after the session. But we're just going to finish with these two questions now. So, do you want to go?
Sure. It's a very quick question. Just to clarify, if you get roadside drug tested, are you implying it's the same sample they take that goes all the way down the line for the 3 tests, or if you get taken to the station, do you get retested?
Yeah, you do. You get retested.
Yeah, so you get retested, yeah.
So the first test is the lick test. Second test is a swab is taken, 2 swabs.
1 swab.
1 swab is taken, and that sample is broken into 2. One goes into the Dragar, and then the second one and the second part of it gets put to the lab.
Okay, I'm asking the question for her. If we believe or have been told that the test, the swab works, by the fact that when you smoke, it goes down into your areoles and your lungs, and every time you exhale, it comes back over your tongue. And that possibly if you take the oil, the drops of oil, even with THC, that they won't necessarily activate the test positive. Is that sound science?
I don't think that is, because you're still taking it orally. It's the same, if you eat cookies, you've got a problem.
It's in your mouth.
So if there's ways of ingesting it so that it doesn't get into your saliva, then that is going to reduce your chances of getting apprehended. Certainly. So short answer is, the government line is, well, just don't do THC. Then you won't have a problem.
Just don't do it.
It's like South Park. All drugs are bad.
So our advice is stop immediately. Enjoy MardiGrass as best you can without smoking anything for the next couple of days. Yep. Thank you all. I think that's the time for us to say thank you for very clever, insightful questions.
Thank you, David Heilpern and Steve Bolt.